It is well known that Apple and Samsung have been under the lawsuit, claiming that their patents regarding designs of products have been infringed. More than 50 lawsuits and hundreds of millions of dollars have been entailed. Why are they so eager to be engaged in such demanding lawsuits? The answer lies in the importance of intellectual properties, IP, in the business. Intellectual properties have and generate monetary value by allowing a firm to get equipped with the exclusivity in the market or freedom to operate. Once owned, generally that firm can only use or sell the rights, securing the business segment's competitive advantages. Samsung case further illustrates the economic power of IP. Samsung awarded 9,588 USA patents in 2015. Considering that IP has positively influenced the GDP of Korea, Samsung has certainly contributed to the dramatic economic growth of Korea, the knowledge-based economy with diverse IPs. Similarly, United States, where Apple is established and also known as the knowledge-based society, has $5.8 trillion for IP industry, which exceeds the nominal GDP of any other countries. Furthermore, America relies on IP for economic growth and employment for more than 40%. Intellectual property, if kept properly as rights, encourages the innovation. It renders incentives to the entrepreneurs to pursue new advances. IP rights catalyze the flow of information by sharing the protected know-how, which leads to the improvements on existing ones or even the innovations. Acknowledging the growing importance of IP, companies also see IP as an asset, even though it is invisible. At present, generating voluntary IP reports is generally recommended in addition to the financial reports. However, it can also be examined as the component of the current financial report. IP in M&A is listed separately as goodwill, the price a buyer is willing to pay in excess of the value of the tangible assets of a firm, whereas the cost, amortization and revenue are all to be considered. Only the revenues generated out of the internally generated IP is recorded. Thus, it should be noted that the ways the companies recognize IP as an asset are still on the developing level. A career in IP can lead to a dynamic and exciting career path such as attorney, IP officer, patient examiner, etc., which includes both a mix of science and technology and also room for communicating with different kinds of people. Generally, the university has the IP rights for works generated by staff. Students retain the IP rights of literary works generated for their coursework. However, if a staff contributes to the student's work by giving ideas for the work, then the university retains the intellectual property rights. If the staff contributes to the idea without the substantial use of university resources, then the staff and the student jointly own the IP rights. If the staff only act as mentor to the student, then the student retains the IP rights. When students participate in competition organised by external organisations, they should be careful about who owns the IP rights. Some organisations mention in their privacy agreements that the IP rights are owned by the company, and so students should carefully read the agreement for these kinds of clauses. Plagiarism means copying someone else's idea and using it as one's own. Plagiarism is a form of copyright infringement, and thus students may face serious consequences such as expulsion from the university if they commit plagiarism.